we continue to look at the divorce case of Dr. and Mrs. Sinclair. We're at the discussion stage, discussion regarding the case, the Maintenance Act, the Property Rights of Spouses Act. Section 3, subsection 2 of the Maintenance Act makes provision for a court hearing matters for the division of property under the Property Rights of Spouses Act to make maintenance orders in accordance with the provisions of that act. It reads, in any case where an application is made for the division of property under the Property Rights of Spouses Act, the court hearing the proceedings under the Property Rights of Spouses Act may make a maintenance order in accordance with the provisions of this act. Remember, I have read through the entire Property Rights of Spouses Act and also the Maintenance Act, but we still look at the sections of those acts that the judge is discussing here. The relevant provisions of the Maintenance Act that addresses maintenance as it relates to the parties before the court are sections 4, 5, and 14. Section 4 reads, each spouse has an obligation so far as he or she is capable to maintain the other spouse to the extent that such maintenance is necessary to meet the reasonable needs of the other spouse, where the other spouse cannot practicably meet the whole or part of these needs, having regards to A, the circumstances specified in section 14, subsection 4, and B, any other circumstances which, in the opinion of the court, the justice of the case requires to be taken into account. So you see, there are certain parts highlighted. So far as he or she is capable, is Dr. Sinclair capable of meeting those needs that Mrs. Sinclair highlighted? Here to meet the reasonable need. That list that Mrs. Sinclair produced for her maintenance, are those needs reasonable? Remember the facial and the manicure and the pedicure and so on and so forth. Some technical issue happening here. But anyway, here, also highlighted is where the other spouse cannot practicably meet. So, is it the case that Mrs. Sinclair cannot practicably meet her needs? Well, we continue. Section 5 reads, a maintenance order for the support of a spouse order, the spouse shall A, contain such provisions as will ensure that the economic burden of child support is shared equitably. The economic burden of child support is shared equitably. So Mrs. Sinclair really needs to get a job and support her children, help to support them. B, make such provisions as the court considered fair with a view to assisting the spouse to becoming able to contribute to that spouse's own support. Subsection 2. In determining the amount and duration of support to be given to a spouse under a maintenance order, the court shall have regard to the following matters in addition to the matters specified in section 4, subsection 4. The length of time of the marriage or cohabitation, the spouse's contribution to the relationship and the economic consequences of the relationship for the spouse, the effect of the responsibilities assumed during the marriage or cohabitation on the spouse's earning capacity, the spouse's needs having regard to the accustomed standard of living during the marriage or cohabitation, whether the spouse has undertaken care of a child of 18 years of age or over who is unable by reason of illness, disability, or other cause to care for himself, any housekeeping, care, child care, or other domestic service performed by the spouse for the family, as if the spouse were devoting the time spent in performing that service in remunerative employment and were contributing the earnings of the family's support. So it's saying that time spent in performing household chores is considered here. So continue. The effect of the spouse's child care responsibilities on the spouse's earnings and career development. So the court considered that if the spouse was taking care of children and that interfered with their career development, then that can be converted into additional maintenance for the spouse. But we continue. The terms of any order made or proposed to be made under the Property Rights of Spouses Act in relation to the property of the parties, the eligibility of either spouse for a pension, allowance, or benefit under any rule, enactment, superannuation fund, or scheme, and the rate that pension allowance or benefit of that pension allowance or benefit. Section 14, subsection 4 reads, in determining the amount and duration of support, the court shall consider all the circumstances of the parties, including the matters specified in section 5, subsection 2, section 9, subsection 2, or section 10, subsection 2, as the case may require, and A, the respondent's and dependent's assets and means. The assets, so the assets, the money, the bank accounts and properties belonging to the respondents and the dependents who are applying for support, and the respondents who is the one who the dependent is saying should support them. B, the assets and means that the dependent and the respondent are likely to have in the future. The dependent's capacity to contribute to the dependent's own support. So in this case, Mrs. Sinclair's capacity to contribute to her own support is to be considered. D, the capacity of the respondent to provide support. In other words, Dr. Sinclair's ability to provide support to Mrs. Sinclair. E, the mental and physical health and age of the dependent and the respondent and the capacity, the capability, or the capacity of each of them for appropriate gainful employment. The court will consider that. Can Mrs. Sinclair be employed? Is she really unemployable? The measures available for the dependent to become able to provide for the dependent's own support, and the length of time and cost involved in enabling the dependent, in this case Mrs. Sinclair, to take those measures. Any legal obligation of the respondent, that's Dr. Sinclair here, or the dependent, Mrs. Sinclair, to provide support for another person, the desirability of the dependent or respondent staying at home to care for a child, any contribution made by the dependent to the realization of the respondent's career potential. So here, any contribution made by Mrs. Sinclair to the realization of Dr. Sinclair's career potential, any other legal right of Mrs. Sinclair to support, I'm changing dependent to Mrs. Sinclair and responding to Dr. Sinclair for now, for Mrs. Sinclair to support other than out of public funds, the extent to which the payment of maintenance to Mrs. Sinclair would increase Mrs. Sinclair's earning capacity by enabling Mrs. Sinclair to undertake a course of education or training to establish herself in a business or otherwise to obtain an adequate income. The quality of the relationship between Mrs. Sinclair and Dr. Sinclair. Any fact or circumstances which, in the opinion of the court, the justice of the case requires to be taken into account. It is clear that the Maintenance Act places an obligation on spouses to maintain each other in circumstances where one spouse is not practically able to meet his or her needs. Okay, so that's one of the highlights of the Maintenance Act. This was aptly expressed by Edward J. Acting, as then was in the case of Margaret Gardner versus Rivington Gardner, 2012. At paragraph 110, she states that maintenance of a spouse is not automatic. It involves necessary capability and reasonability. So, just because your spouse applies for maintenance does not mean the court will just shut its eyes and say, yes, you must maintain them. It's not automatic. It must be necessary, and you must be capable of maintaining your spouse, and that maintenance must be reasonable. That's what this is saying. Okay. So, here, the Act also indicate that needs should be assessed based on accustomed or expected standard of living during the marriage. The court, in awarding an appropriate sum for maintenance, should take into consideration the other circumstances outlined in section 5 and 14 subsection 4, one of which is to ensure that the economic burden of child support is shared equitably. So you see that. So if this is a case where if you are going through a divorce or about to go through a divorce These are some of the things that you might want to note. All right. Your spouse applies for maintenance, or you apply for maintenance for your spouse. You should make note that it must be reasonable. The court will consider all the circumstances, so you must have your evidence to present. And here, ensure the act, Maintenance Act, right? Ensure that the economic burden of child support is shared equitably. So if your spouse is not employed, it is reasonable that the court requires that that spouse find a job and help you to maintain that child or those children. But we continue. In the case of Suzette Usam versus Quintin Usam, 2015, E. Brown J. expounded on the principle governing spousal maintenance by stating, right, we see here, it must be demonstrated by evidence, firstly, that the spouse who is tasked with the responsibility for spousal maintenance has the capability to fulfill that role. Secondly, the claimed maintenance must be demonstrably necessary. It must be necessary. Thirdly, the needs being considered must meet the bar of reasonableness. Finally, the evidence must show that it is impracticable for the spouse to wholly or partly satisfy those needs. It is impractical for the spouse to wholly or partly satisfy those needs. So that table of requirements that Mrs. Sinclair has presented, which required $835,000 per month and included $200,000 for grocery and what was it, $20,000 for facial and massage and so on and so forth. That does not seem to be safe, because the question is, are they reasonable? And I'm sure they are, or will be found to be unreasonable. But we continue here. Therefore, in deciding whether or not one spouse should be ordered to maintain the other spouse, the court must make certain essential determinations. As such, the court is required to determine whether at the time that the matter is being heard, the claimant's spouse is able to meet her reasonable needs. In the instant case, it is clear on the evidence of both parties that presently the claimant, Mrs. Sinclair, is not able to meet her reasonable needs. Both parties have admitted that she presently unemployed and has been so for over 20 years of the marriage. Both parties admit that she, Mrs. Sinclair, worked for approximately 2 years during the marriage. It is also the undeniable evidence that during the course of the marriage, up to the time of separation, she depended on her husband to meet her financial need. Okay, so it is accepted that Mrs. Sinclair is not capable at this time to meet all of her reasonable needs. All right, fair enough. I must also decide whether the spouse who is being asked to provide the spousal maintenance, in this case, Mr. Sinclair, has the capability to so provide. The evidence clearly points to Mr. Sinclair possessing the capability to provide maintenance for his wife. He is gainfully employed and owns shares in several companies. Despite his medical condition of vertigo and its limitation, the defendant has admitted that Dr. Sinclair has admitted that currently there is no grave impact on his ability to carry on his career. Additionally, he has admitted that when balancing his listed obligations/expenses against his income, he is left with a surplus of approximately $1 million. However, the fact that it is established on the evidence that the defendant has this surplus does not mean that the claimant will automatically receive the level of maintenance that she seeks. She must meet the requirements laid down by the Maintenance Act and the cases. In keeping with the established principles of law, the court will make orders to meet the costs of needs that are reasonable. This assessment will be made in accordance with the lifestyle of the claimant. This assessment will be made in accordance with the lifestyle that the claimant, Mrs. Sinclair, has been accustomed. Therefore, it must be demonstrated on the evidence that the items and costs for which Mrs. Sinclair is seeking maintenance are reasonable. It must be demonstrated on the evidence. All right. In the instant case that Mrs. Sinclair has listed several items of need for which no supporting evidence has been provided, here we saw that. For example, whereas she should have had no difficulties obtaining bills from the only providers of electricity and water in Jamaica, she has presented no utility bills. So as you see here, when you go to court, you cannot go with just something that you're right. You must go with evidence, documented evidence. And in this case, she had neglected to carry utility bills. Additionally, she should have presented some supermarket receipts for the cost that she listed for the items. Groceries. Groceries, $200,000 per month. Wow. Furthermore, it is my view that some items listed by the claimant appear to be unreasonable. She has not substantiated the need for facial and massage every month, or the cost for the entertainment, or what this entertainment entails. That is, she has adduced no evidence that during the marriage she was accustomed to having facial and massage every month, or what type of entertainment she has become accustomed to. I just paused and looked up the meaning of the word. It seems to be adopted. Adopt. From the Latin, adoptus means to drawn towards. Alternatively, a contradiction or addition product. Okay, that's reasonable. All right. I must also make the observation that the defendant himself, Dr. Sinclair, has failed to provide documentary evidence in relation to his expenses for some of the items he has listed. This is apart from his loan obligation. So here you see, when you going through a divorce or other case and going to the court, documented evidence is what the judge will look at. If there is no documented evidence, the judge will only look at any reasonable costs, which would likely be a lot less than what you're submitting. All right. Now, at this point, we will pause and continue reading this case in another video.